Hello, I'm Lorette Ligon, the president of the Jacksonville Onslow Chamber of Commerce. And on behalf of the chamber membership and the board of directors, I want to welcome you to a forum Onslow. The chamber works with government agencies on issues that affect our business community. We monitor legislative issues that impact local business. We promote partnerships between business, government, military, and education. And we use these forums to create awareness on topics that are important to the entire community, such as the election of those that represent us on the state and local level. We are pleased to have Duke Energy as the sponsor of this Meet the Candidates Forum. Derek Riemer is the district manager for Duke Energy North Carolina Government and Community Relations. His territory is Onslow, Jones, Pitt, Carteret, Duplin, Wayne, Lenoir, Craven, Pamlico, Beaufort, and Greene counties. As you can imagine, he is a busy man, but he did record a message for you today.
Hello and welcome, candidates. I am Derek Riemer, your district manager for Government and Community Relations for Duke Energy. We are proud to sponsor these candidate forums and thank the Chamber of Commerce for working hard to make sure you're given this opportunity. At Duke Energy, I'm excited about informing the community of the Carolinas Carbon Plan, which will focus on reducing our carbon emissions by 70% by 2030 and going net zero by 2050. The commitment to creating a cleaner environment will include transformative and innovative strategies like renewables and grid investments. A recent example of this can be seen at the existing solar facility at Camp Lejeune, where we will soon be adding large-scale battery storage to supplement the solar facility for when the sun isn't shining. This will help with not only a cleaner energy solution, but our resiliency efforts as well. Having worked in government for a number of years, I want to express my personal thanks to you and your families for your willingness to serve. It's not an easy decision to enter into public service, but know that we thank you and have a great forum.
All right, it's time to begin our forum, and I'd like to introduce our moderator, Elliot Potter. He's a retired newspaperman who served as editor of the Daily News for more than 40 years. He currently works as a communications consultant, including helping One Place and its Child Advocacy Center spread the word about protecting our children. Ladies and gentlemen, Mr. Elliot Potter.
Thanks, Lorette, and welcome to our audience and, of course, our candidates. These are the candidates. These are the Republican candidates for district attorney for the 5th Judicial District, which covers Onslow, Jones, Duplin, and Sampson counties. And I do want to go over candidates. I want to go over some of our basic rules of engagement here. One of the things that I always open up with is to remind you that this is a forum and not a debate, even though we only have 2 candidates today, so hopefully we'll have some time to get into some issues. But we would ask that you address your responses to the audience and to the moderator and not each other. And so that's one thing that we do ask. All of our questions will be general in nature, and so they're suitable for the both of you. Opening remarks will be 60 seconds in length. Each candidate was asked to state your name, provide background information that introduces yourself to the audience, and include where you reside in the area and your current occupation. We also, please give us an idea about why you are running for this office. Each candidate is going to have, this time we're going to extend this a little bit to 90 seconds to answer the questions. We will alternate the order of questioning, and at the end of each round of questions, you will have an opportunity to use, on 2 occasions, you can use your rebuttal cards, your cards there. Just indicate, raise your card, let me know if you would like to add to your response. And we'll do that at the end of the full round of questions. And at the end, of course, we'll have summations, and you will each have 1 minute for the summations. We do have a system for letting you know how the time is going, and so we ask that you adhere to the time limits. During the Q&A round, a yellow light will mean that you have 15 seconds remaining to complete your response. During the rebuttals, same thing, yellow light will tell you that you've got 15 seconds remaining. When you see the red light, that means your time is up, and we ask that you complete the sentence that you're on and then stop. And that means not necessarily completing your thought, and we apologize for that, but we want to try to do this as efficiently and fairly as possible. We also ask the audience to please refrain from applause during the program, and we'll just make that happen at the end. So I will ask you if you have any questions.
No, sir.
And if not, we'll get started. And I will open up, Mr. Kiernan, you will have, Kevin Kiernan will have the first opportunity for an opening statement, and the first question then will go open up with Ernie Lee. Mr. Kiernan.
Well, thank you for having us here today. My name is Kevin Kiernan. I reside in Kenansville, right in the center of our district. I was born in Greenville, North Carolina, raised in southeastern North Carolina. I live 50 miles from the hospital where I was born. I am running to give the voters their first choice in approximately 20 years on the ballot. I am a constitutional conservative. I was an assistant district attorney in this same district for about 5.5 years, practiced in all 4 of the counties as a prosecutor at that time. The last 9 years I have been in private practice. I am a small business owner. As a small business owner, I know what it means to train personnel, bring out the best in personnel, and also have the ability for conservative and fiscal responsibility and efficient use of resources. I am running not just for that choice, but to give that conservative the constitutional basis of a choice and to bring a proactive nature to this office in every facet of the office, not just in working with law enforcement, but also in dealing with cases, prioritizing cases, and making use of all of the court terms that are available to the best possible use of those terms. Thank you.
Okay, I'm sorry, the timer was set on 1.5 minutes, so you'll have 1.5 minutes, Mr. Lee, for your opening statement.
Hello, my name is Ernie Lee. I am your district attorney for the 5th Prosecutorial District. I was born in New Bern, North Carolina. I was raised in a military family. Military service has been very important to me and my family. My father retired from the United States Air Force. My brother also retired from the United States Air Force. I then served my country 22 years in the United States Army Reserve as a judge, advocate, and commissioned officer. I believe in family values. My wife and I and our 3 children have lived in Onslow County now for 35 years. I've been married for 31 years, and I really love this area. I'm a career prosecutor, and the reason I'm seeking re-election as your district attorney is because, first of all, I care, first and foremost, about victims' rights. I care about victims' rights. I also care about law enforcement and the enforcement of the laws. That includes all the laws, including the DWI laws in this district. I also am an advocate for those that have been injured, those who have been victimized. They need a strong and experienced voice in the courtroom, and that's who I have been now for 35 years. I believe this job is a serious job. It demands experience. I have that experience. I have that temperament. And I am wanting to be and to continue to be your district attorney for this district.
Okay, thank you, candidates. Mr. Lee, you will start off this round of questions. And my first question is, what have been your main takeaways from meeting people on the campaign trail when they tell you what they expect or want from the district attorney's office?
I can tell you what the people want from a district attorney's experience. And I heard that again as late as yesterday. People want true experience. As I told you, I'm a career prosecutor, and here's why experience is so very important. If you are the victim of a crime or some family member of yours has been murdered, you want to go into the district attorney's office and know that that district attorney who will be handling that case has actually tried a case like that before. My opponent has never tried a murder case. Never. In 14 years being a prosecutor, as I've been a defensor, he's never tried a murder case. I have handled 145 first-degree murder defendants. I just tried a murder case back in February. So experience is the key thing that people want. They want to know that they have confidence in you. And the way they get confidence in you is letting them know what your experience is, the type of cases you've tried. And I can tell you, people may come into my office and ask me a lot of questions, but they've never asked me my political party. They've never asked me how many political events I've attended, but they have asked me, Mr. Lee, have you ever tried a murder case before or some other type of case? And then the second question is, have you ever tried a case like mine? Because victims want that from us. They demand that from us, and I have the experience to provide that.
Thank you. Mr. Kiernan, the question is, what have been your main takeaways from meeting people on the campaign trail? And what do they tell you when they say what they expect or want from the district attorney's office?
I'll start with the main thing they say as far as what they expect from the DA's office, and from me in particular if I were to succeed. They are expecting consistency, leadership, conservative values, and transparency. And that is what every conversation I have had boils back down to. We talk about the experience, we talk about the political backgrounds. At the end of each conversation, it comes back to the next time we have a pandemic, are you going to shut down small businesses if the governor issues a mandate that most people feel is unconstitutional? They ask me, are you going to work with law enforcement? Are you going to remain transparent? Are you going to work alongside them and not dictate to them what needs to be done? And the other thing that comes back a lot and has over the past month is, are you going to make efficient use of the court time that you are provided? Because right now, what we are facing is the last 3 trials here in Onslow resulted in not guilty verdicts. In Duplin County, the first felony trial that we're having this year is this week. It's one where the voters are looking at it and saying, we want to see the leadership from the top down. We want to see you out and about in all the counties, not just one, all 4, and not just concentrating on one case, but all cases, so that we know everyone is getting attention.
Okay. Thank you. And Mr. Kiernan, you will have the first crack at the second question. What element or elements of your personal background have been most influential in preparing you for the office of district attorney?
There are several. Obviously, I was an assistant district attorney for 5.5 years, so I have that background in the prosecution realm, was able to network and get along with quite a few law enforcement officers that are still friends of mine, that I still discuss cases with, some of whom have called me when they can't get a hold of an ADA to ask a question about a search warrant. That's one basis. The other is my diverse background of employment and just interacting with the public. I have worked in retail, I have built computers, I have run my own business, I have run my own retail business. It is a matter, my background schooling-wise is I have a degree in computer science. So when we are looking at the cases that are coming before the DA's office moving forward, many more of them, the evidence is becoming more computer and digital centric. We have many cases that are dealing with lab matters, chemistry. Both my parents were bench chemists, so I grew up in that atmosphere. I have a full understanding of that. When we're talking about evidence coming from Facebook, Snapchat, emails, and my opponent has mentioned that while he agrees with that, he doesn't understand some of those things. I know how all of those work. So I know how to talk with the people that develop that information and be able to bring it across to a jury in a very common sense way.
Thank you. Mr. Lee, would you like me to repeat the question, or just asking basically what elements of your background have best prepared you for the office of district attorney?
You know, I've grown up with conservative values my entire life. I have been a lifelong conservative. You can look at my record and know that. You know, I can tell you the things that most influenced me is, first of all, I grew up in a military family, which teaches you duty. It really does teach you duty and service. I'm very proud of my military service. And that has really taught me a lot of the value of serving others, and more importantly, serving this nation. Hard work is another thing. I've been working since the age of 16. I paid my way through college and law school. I've worked my way since 16. I believe the value of hard work. Most days, I'm the first one at the office and the last one to leave because I want to set the example for my prosecutors. Family. Family's very important to me. I've been very proud of the fact my wife has been accompanying me on almost everything during this campaign season, and I appreciate that so much. It's a sacrifice that she has made, and I truly appreciate that. We have 3 wonderful children, which are very important to me, which even makes it more important. I remain the district attorney to make sure this district remains safe, this county remains safe. And then finally, but foremost, is faith. I've been a Christian since the age of 12 years. I'm an active Gideon, which means I'm one of those people who goes out and speaks to churches and places Bibles and motels and hotels. Christianity is not something just for the campaign season. It's a way of life for me.
Okay, thank you. Move on to the next question, and I believe, Mr. Lee, you start this round.
Okay, sir.
When all or a portion of a prosecutor's district suffers a substantial impact of a certain kind of crime, let's say it's gun violence or opioid abuse or a rash of property crimes, is it proper or helpful for the DA's office to respond with a specific strategy for prosecutions?
Yes, sir. I can tell you that, for example, here in Onslow County, we've had a significant opioid epidemic, particularly in the Seas Ferry area. This is something my office and I have dealt with quite a bit. In fact, my office was one of the first, if not the first, and I was part of this prosecution, to actually charge someone causing the death of someone to opioid abuse. I went down and met with a family down in Seas Ferry. I met with law enforcement, the Onslow County Sheriff's Office, and we began an investigation. We were actually able to charge the individual with that. I then also worked with District Attorney Ben David over in New Hanover County because that case actually went over in his district over in Pender. Yes, it's very important to do that. One of the things I've done in this office as well is I've had some specialized prosecutors, violent crimes as well as sex offenses. Sex offenders are so very important that you have specialized training because you're having to deal with young children. These are very difficult cases. You're catching someone at the worst time of their life. Either the victim has been victimized or their family's having to live through that victimization. And so I have had prosecutors assigned to those. Same thing, if we find out there's a particular area of gun violence or whatever, I will work with the local sheriff or the local police chief to make sure we're putting the resources we need to in those type of offenses. We take crime very seriously in this district because wherever there's a crime, almost likely there's going to be a victim. And we're out there to protect the victim's rights.
Mr. Kiernan, the question before you is when all or a portion of a prosecutor's district suffers a substantial impact from a certain kind of crime, let's say it might be related to gun violence or opioid abuse or other drug abuse, a rash of property crimes, would it be proper or helpful for the DA's office to respond with a specific strategy for prosecutions?
It would absolutely be both helpful and proper. The few things that come to mind, number one, we had the aftermath of the hurricanes and all of the damage that was left behind. Another piece that I have encountered on the campaign trail and talking to folks is there were several folks, most of them elderly, that indicated they were not pleased with the response where they were scammed on repairs. There is one office that spans the entire district in terms of the executive branch, that's the DA's office. So when you have crimes that cross county lines, for instance, I was talking with narcotics officers in Jacksonville that indicated they had a suspect that what they thought may be involved in something in a county still within the district, but they weren't having good communications back and forth. The DA's office is the centerpiece there, and that's where I was saying earlier, it cannot be a dictation of you need to do that, you need to do that. It becomes, let's come together, let me be the bridge, let us keep this dialogue open. So it's not just about the violent crimes and keeping that across. It's about DWIs and training. It's about drugs. Most of our crimes come back to drugs. And it's about working with these officers, with these task force officers that bring an immense amount of experience to the table, but they're seeing different outcomes within the counties within the same district. And if we have one unified approach that's proactive, we can address that most properly.
Okay. Mr. Kiernan, you get next crack at this question. I'm going to dig a little deeper into that topic. What impact has the ongoing opioid epidemic influenced your mindset, or how has it influenced your mindset on the prosecution of all drug-related crimes? And specifically, if you don't mind talking about marijuana.
I will talk about each of those. It has definitely impacted me at an individual level. In the last 18 months, I have seen more people die of overdoses that I am familiar with from within the court system, either clients or past people I had prosecuted. I've seen that number rise. It's the highest that it has been in my time. So it has definitely had an impact on how I would view those things. I come back to it and say, in talking with law enforcement, and we see this as well, the bulk of crime is initiated through usually either mental illness or drugs. That is one where we have to have a more concerted, proactive effort, pulling together and tying in the task forces across the district in terms of drug prosecutions. They want to, in terms of law enforcement, be able to carry out an entire investigation, but they need to know that the DA's office is going to be willing to work with them with CIs, with working up that ladder, not letting the smaller fish go entirely, getting those convictions, but in turn, turning those into bigger cases and convictions on the ones causing the problem. In terms of marijuana, it is presently illegal. And at that point in time, that's what we're looking at with the law, which means that is still illegal. That is still something that would be prosecuted. Most of what we're seeing now, from what I'm hearing, is those marijuana cases are intertwined because now it's being connected with fentanyl being laced.
Okay, thank you. Mr. Lee, you want me to repeat the question?
No,
You
sir.
got that?
I've got it, sir.
Okay.
I can tell you drug and alcohol abuse have been devastating in our communities. Ever since I've been a prosecutor, the only thing that's changed is the type of drugs. But drugs, whatever they may be, controlled substances and alcohol, are devastating to our families and to our communities. And that is one of the reasons I have been tough on trafficking cases. I am not one who's just going to reduce them down to attempted so they can get probation. I am not one on sale of cocaine or other drugs who's going to reduce those down so the defendant can be helped. I'm not going to do that. I've been tough on DWIs, including the .08 law. My opponent is not so much in favor of that. But nonetheless, driving while impaired is a serious offense. In terms of the opioid epidemic, it has been an epidemic in this district, in this county. I can tell you, I was one of those prosecutors who actually went to the North Carolina General Assembly to increase the punishment for selling drugs that cause death, and including come up with a new offense called death by distribution. I worked with District Attorney Ben David in New Hanover County to implement that. I was actually assigned to a committee up there at the legislature representing the district attorneys in order to make some of our drug laws tougher. Look, I can tell you that drugs are devastating. They break up families. They cause accidents. They cause people to lose their jobs, get kicked out of college, whatever it may be. Alcohol and drugs do all those things, and we've got to address them.
Thank you. And Mr. Kiernan, you've indicated you'd like another 30 seconds for response.
Yes, I absolutely do take DWI seriously, which is why I have invested my own money to get all of the same training that I can under law that law enforcement does as far as the NHTSA-approved SFST courses. There's not a single DA in the DA's office that has that training. I would bring that to the entire office. I should not be winning some of the cases I am winning if they had that better training. And as to law enforcement taking it seriously, just yesterday, I counseled a police officer and a trooper after court when they were asking me, what can we do better so we avoid not guilties? And I told them exactly what I thought that they could do better.
Okay, thank you. And this question, I believe, opens up with Mr. Lee.
Yes, sir.
In what ways do cases that involve what is known to the public, and to, there's probably because of TV, but special victims,
Yes, sir.
often their children or others who are victims of sex crimes and other forms of abuse, in what ways does that require a different approach from the DA's office?
You know, I can tell you, when you go to law school, they do not teach you how to talk to children victims. They do not teach you that. That is something you must acquire from years of experience. I don't think Mr. Kiernan has ever tried a sex offense case. He's ever tried one. I have tried many in my career. I was a prosecutor. I think he said in one second-degree rape case, he served as second chair on it over in Sampson County, but he's never tried a case involving a child victim. I have tried those type cases, and this is what you've got to do. It's more than just the district attorney's office. You've got to have law enforcement trained up so they know how to speak to these children. But more importantly, you need a child advocacy center or someplace like one place here in Onslow County. We need one for all the counties in this state. That way, these children can go someplace, their families can go someplace, and they can be treated and spoken to. They need to be prepared. And I can tell you, we are very fortunate in Onslow County to have something like the Child Advocacy Center. That's what we need. We did not have that when I first started at the DA's office, and it was sorely missed. It's one of those things that we've got to use all the resources. I feel for these victims of child abuse. And what is so very sad right now, there's a victim somewhere in this county, in this city, who's being victimized, but they don't know who to go to. We don't know when they're going to ever report it. But I do want them to know that if they ever do report, they're going to have an experienced prosecutor and myself in my office to prosecute that case.
Mr. Kiernan?
First of all, I've tried several sex offense cases, which is a little odd to hear since I did that under Mr. Lee. I sat first chair on a rape case in Sampson County. I actually broke the rules that he provided to us in Duplin County when we were told, do not interact with district court, you're in Superior Court. Any questions from there need to come straight to me. I had an assistant district attorney that was a younger attorney that came to me one day from district court about a case that did not sound right, that was charged as a misdemeanor. We had that case recharged after an investigation. I tried that case, first chair, to a guilty verdict, and that young man, that actually middle-aged man, went to prison for around 6 to 8 years instead of going home. That's what I'm talking about in terms of leadership up and down the ranks and being involved in these cases day in and day out and understanding. I also tried a sex offense case, multiple sex offense cases in juvenile court with young victims that I had to sit and talk with these victims about what occurred. And I'm talking everywhere from 3 years old up until 10 years old. Child advocacy centers are outstanding and they are what we need. The problem that I see as a defense attorney, I get discovery and we have the multidisciplinary meetings. There's a decision made to charge, and my client gets charged 6 months later. So what is happening in that 6 months that we're not being proactive?
Okay, thank you. Mr. Lee would like to have 30-second response.
I'll tell you, that shows his lack of experience. What's going on in those 6 months is an investigation is ongoing. That shows his lack of experience because these cases must be investigated. And as a defense attorney, as a former prosecutor, he ought to realize that. You've got to investigate these cases. The DA's office does not investigate. We rely upon law enforcement to investigate, and that's what's going on in those 6 months.
Okay,
Pardon me, can I rebut now or?
thank you. The next question, I believe, goes to Mr. Kiernan. I'd like to ask, again, another little follow-up to what we were just talking about. Are there instances in which the well-being and recovery of a victim can impact the state's approach in prosecuting a case? And just explain your answer.
I think it definitely does and should, and under the Victims' Rights Act, they have that right, as they should, to be heard by the DA's office as to what they would like to see happen with the case, what has already impacted them about the case, and what could be the future impact. That is why the investigation is important. What I was referencing in the advocacy centers is this is after the investigation is complete, after it is turned over and given to a team, and a group decision is made to charge. The charge is not occurring for several months in several cases. That is an immediate impact on any victim. When we're talking about how to address a particular case, it definitely comes down to what is your evidence, what is the potential outcome of that case, what is the impact on the individual victim, and what are their desires. There are certain cases that don't have as much impact. Maybe it's somebody stole my phone and I don't want to prosecute. That's one thing. It might be something where it's an armed robbery, some type of a more serious assault, and maybe the victim is a little concerned about how to handle the case. At the DA's office, you've got to find a way to proceed on an evidence-based prosecution on those if it exists, because that person is dangerous. And even if you have victims that don't want to participate, you've got to try to find a way to do that if you can. I have done that in a case fully evidence-based without a victim in the courtroom and obtained a conviction on a habitual felon.
Thank you. Mr. Lee?
If you repeat the
I
question,
sure will.
sir.
Are there instances in which the well-being and recovery of a victim can impact the state's approach in prosecuting a case? And I ask you to explain your answer.
Yes, sir. Obviously, with the Victims' Rights Act, and even before that, I was very much an advocate for victims. As a prosecutor, I will meet with the victim's family initially in a case. I will let them know about what they can expect, but more importantly, I'm just trying to find out more about them and their victim, their family member who may have been victimized. I let them know that ultimately it's the DA's office that must make the decisions. However, I will let them know the options, what is going to be happening in the case. And I've had years of experience in doing this. I will talk to these families, ensure that they understand the procedures, how long it's going to take, what they expect from the other side, the type of preparation we're going to go through. And we do this on a routine basis. I have a lot of legal assistants. I have 39 people who work for me in this district. Talk about a large law firm spread over 4 counties. And I have a lot of legal assistants who spend an inordinate amount of time, which is well-deserved time, talking to victims and their families about their cases. Because we want the victims to feel like, first of all, they're part of the process, not to be re-victimized by anyone, but also that way they can receive some degree of closure. Victims deserve that. I can never give back a victim's family, like in a homicide, what they want, which is their loved one back. But I can give them some degree of closure. And I can give that degree of closure because they have the experience to do so.
Okay, thank you. And I believe, Mr. Lee, you have a first crack at this question.
Okay, sir.
What should determine whether children are charged in adult court? When would you use your authority to file charges in adult court, and when would you pursue a case in juvenile court?
Yeah, that's a good question because, obviously we've just changed the law recently where it went from 16 to 18 for juveniles in the state of North Carolina. One of the things we got to look at is, first of all, the seriousness of the offense. If it's going to be a murder case, it's going to be treated as an adult. And that goes without saying. I, in fact, have prosecuted an individual over in Duplin County for murder. He was 14 years of age at the time. I had him transferred to Superior Court. I did that case myself. I did not delegate it to an assistant DA. I handled it myself. What we'll do is look at the seriousness of the offense. We'll look at the record of the individual. We're going to look at the type of crime that was committed. And then you look at strength of case. We will also consult with the victims and determine what is best in this case. In addition to that, I will consult with law enforcement and juvenile intake officers to find out what is the best we can do in this particular case. Is this a child who can be saved? Or is this the child that basically will continue to commit crimes? I look at all those things. Juvenile court is very serious. It is a very serious thing. We've had children as young as 13, 14, 15 committing very horrible offenses. If those offenses are really bad, the DA's office has the option of going in and sending those to Superior Court as an adult.
Okay, Mr. Kiernan?
In terms of making the decisions of whether to bring a juvenile into adult court, there are 2 parts to that. One, certainly you look at the offense, you look at that juvenile's history, you look at the surrounding events. Was it something within a family, without a family, so forth? There is a second component that once something proceeds from juvenile court through probable cause hearing, it automatically transfers into Superior Court under certain cases. Homicides, the high-degree sex offenses, those are going to automatically transfer jurisdiction to Superior Court. So you have to make that decision earlier on in the case as far as if you're proceeding through a probable cause hearing and so forth in juvenile court. Again, you've got to be that proactive. Talk with the juvenile court counselors, talk with the detectives in charge, talk with the families involved in the case. In terms of cases that have come out of juvenile court, there was a case that Mr. Lee and I both had that was a 14-year-old in Sampson County. When he had mentioned that I've not been first chair on a homicide case, I was actually appointed to that case to defend that young man, and his office is on record saying that I was more than qualified to handle the case. We did not have a trial. We were prepared for a trial. I ended up filing a suppression hearing that was one of the first of its type in our state. We succeeded, and that case was later dismissed. So I do have that homicide experience, adult, juvenile combined, and have had the outcomes to show that.
Okay, thank you. Mr. Kiernan, you will have first crack at this question. What is the proper relationship between the district attorney's office and the law enforcement agencies that investigate the cases that must be prosecuted? Are there boundaries that must be maintained?
There are definitely boundaries that must be maintained. And that is one of the primary issues that I have encountered in talking with law enforcement, both in the suggestion of many of those road line officers, detectives that have asked me to run for this position. Because their feeling is the DA's office tells us what to do, charge that, don't do this. What I believe, both by the designation of the offices, as far as district attorney is elected, sheriffs are elected, it has to be a collaborative effort. That's another part of coming back to that proactive communication, collaborative, not coming and doing trainings randomly during a campaign time, but otherwise not. I've been doing basic law enforcement training, the courtroom exercises, for 15 years straight, every single time, because I take it that seriously. When I was a prosecutor, I worked with detectives. I never told them, do that. I said, hey, can we talk? How about we try this? And they would say, what if I try this? It's amazing the outcomes you come to when you're working at the same level as you should be, because neither side works for the other. They should be working together. And when that happens across our district, keeping communications open from county to county across the district, then you will see what this district attorney's office can truly do.
Mr. Lee?
Look, I have a great relationship with law enforcement. I'm supported by all 4 sheriffs in this district. All 4 have supported me. They did not support Mr. Kiernan, they supported me because they know I have a long record of working with law enforcement, trying cases, providing sound legal advice, and working hard. I've been teaching law enforcement long before Mr. Kiernan ever came to the DA's office. Long before he started, I was doing that. And I still do that. And in addition to that, I have a constitutional duty to advise law enforcement. And I can tell you, when those law enforcement officers call you, it's usually like at 2, 3 in the morning, they're calling about a murder case. Mr. Lee, what should we do? They are calling me, the elected district attorney, and it's usually the sheriffs themselves, and then their senior chief deputies calling me. And I've been able to provide those answers. Why? Because I have, in fact, tried those cases. Mr. Kiernan mentioned that case over in Sampson County. That was a defense case. He was the defense. He has never tried a murder case. That's the bottom line. He can't escape that. He's never prosecuted a murder case in trial, ever, ever. And he also, one thing he always leaves out, I'm the one who dismissed that case. He always says it was dismissed. I dismissed that case as the elected district attorney because it was the right thing to do pursuant to the law.
Okay. Mr. Kiernan, we hear a lot about the backlog of cases at the court system. I'm sorry, I believe I'm supposed to start with Mr. Lee this time. I apologize for that. I get mixed up, man. It's early in the morning for me. I'm retired.
I understand.
Mr. Lee, we'll start with you. We hear a lot about the backlog of cases in the court system. What do you see as the primary cause of the backlog? And do you believe the situation has reached a point where it's impacting the quality of justice?
Yeah, it concerns me all the time. Look, I wake up thinking about this. This is something Mr. Kiernan can't even dream about because I wake up to these murder cases we've got pending, these other old serious cases we have pending. Yes, first of all, we lost one entire year of jury trials because of the COVID epidemic, the pandemic that swept this nation. We lost an entire year from March of 2020 to March of 2021 where we could not try cases, jury trials. However, we were able to dispose of other cases through guilty pleas. That concerns me. We are trying to catch up from that backlog, just like the rest of the country and the rest of the state of North Carolina. In addition, one thing that does bother me is defense comes in, they're never ready for trial, it seems like. They've always got to make a motion to continue. Come on, let's get ready. We shouldn't have to schedule a murder case 3, 4, 5 times before you're finally ready. We provide discovery early in this county. We provide discovery often as required to by statute. And look, if the state can be ready, defense be ready, because that just simply delays the cases. Look, I'm a big proponent of being proactive in these cases. I talk to my assistant DAs so much. I keep track of the stats for each county, the number of trials being done. I question them why this case wasn't tried or that case wasn't tried. I encourage my prosecutors to try cases because you become a better prosecutor if you know how to try cases, and I have done that.
Okay, thank you. Mr. Kiernan.
Well, first, there certainly is a backlog across the district that we're still climbing out of. As far as seeing that on a daily basis, I certainly did. I was in Superior Court handling many of these pleas that occurred during that year where the court was otherwise shut down to jury trials, and inexplicably, district court was shut down to trials, even though we did not need as many people. In district court, you could see physically the files, because we had some of our counties, all the files would fit in one vertical filing cabinet. By the time we started court back, there were two. So you could literally see we had increased by 100% the caseload. That's something that has to be climbed out of. That, again, is in district, that's in Superior Court, that is mandatory that you make efficient use of court time. We had a year where nothing was tried, where every prosecutor in this district should have been looking at their cases of, what do I have that I know is for trial that is a serious case that we can move forward? We're talking about cases not needing to be continued. This week, as I understand it, it was the state's case that had to be continued that led to now trying misdemeanor appeals instead of these serious cases where we have people sitting in jail for that 1 year plus years on top of that waiting for trial. We should be prioritizing those cases over misdemeanor appeals. We should be getting those cases tried. We just had a case that was tried, found not guilty, where the gentleman had been in jail for 1,000 days.
Thank you. Mr. Kiernan, you get first crack at this question. We hear the term victims' rights often used in relation to prosecution. We've heard it today. What does that term mean to you?
It means twofold, in my opinion. Obviously, there's the legal component where the Victims' Rights Act, the victims involved in certain cases that are laid out in terms of what the statutes are, that they have a specific lineation of rights, the right to communication, the right to know what's happening within a case, the right to give their input, their impact that they have felt. But I believe there is a second component on a personal level that is their case. As seriously as anyone else can take the case, no one is ever going to feel it as personally as the victim of that case. That is their case. They have a personal ownership of that case. And in that way, they have every right, even if the statute and the amendments were not there, to be involved in that process, to know what is happening. For their families, the victims of homicides, to know what is happening. I should not get calls from victims' families in a homicide case asking if I will meet with them so that I can get them information on the case because they're not obtaining that information from the channels that they should be able to. That is how I see this in terms of victims' rights. It's not just a talking point. Most people have been the victim of a crime at some point, and it is a very personal level matter. And they have to be factored in. They have to be treated, not just because you're supposed to and not just if somebody's looking at you that day, but all times with respect and being included. Again, that transparency, communication, proactive.
Thank you. Mr. Lee.
Look, Mr. Kiernan used to work with me. He knows how I treat victims, the amount of time I put in cases, the amount of hard work I do. He knows that. And I tried to instill in him those same values. Whether I was successful or not, I don't know. But nonetheless, I tried to instill those same values in him and all my prosecutors that have worked for me. I have dealt with at least 140 victims' families in murder cases. 140. Which is a sad commentary on the state and nation when you think about that. Personally, I've dealt with 140 families, so I know how to talk to victims' families. What you're supposed to do is basically advise them. Let them know what is coming up. Let them know what they'll be facing in court. Let them know from your own experience what they will be dealing with over the next few years as this case winds its way through the criminal justice system. Let them know those things. Comfort those families. Second is, to make sure that they're somehow made whole as much as you can, whether it be through restitution, prison time for the defendant, or whatever the case may be. And then also be there for those victims post-conviction. I've got families now I'm still dealing with from the 1990s, victims' families. I tried their murder cases. I still deal with those families from post-conviction. You know, what the families want is competent and experienced guidance, counsel, and advice, and I provide that.
Okay, thank you. And you will get the, Mr. Lee, you will get the first crack at this question. The death penalty continues to be a source of much debate in North Carolina and elsewhere. What are your feelings about the death penalty and when it should be considered?
Sir, I'm very much in favor of the death penalty. I'm the only candidate who has ever tried a death penalty case. I'm the only candidate who's actually talked to a family in a death penalty case. I'm the only prosecutor who has obtained death sentences in death penalty cases. I've obtained 4 death sentences as the lead, 3 as lead chair, 1 as second chair. I have done those things. Look, I am very much in favor of the death penalty. I cannot tell you that it serves as a deterrent to other crimes, but I can tell you what, if that defendant is executed, it serves as a deterrent to him or her. And that's what I believe about the death penalty. I can tell you right now, there's not been anyone executed in the state of North Carolina since 2006 because there's so many legal holdups on that. I've got 4 first-degree murder cases I have declared capital at this time. I'm prepared to go forward with those cases. I'm very much in favor of the death penalty. I believe that it should be used in the state of North Carolina. I believe there are certain cases out there that are so horrific, so awful, that shock the conscience, that should receive the death penalty. And I have sought the death penalty in those type cases. Again, I had 4 people on death row. Mr. Kiernan has never tried a death penalty case. He's never tried a murder case. I don't know how he'd ever try a death penalty case if you haven't done a first-degree murder case itself. But I can tell you, those cases, they take a lot of experience, a lot of time, a lot of effort.
Mr. Kiernan, the question again is the death penalty continues to be a source of much debate in North Carolina. What are your feelings about the death penalty and when it should be considered?
I do support the death penalty. There are 2 pieces there when the discussion is about when it should be sought. Obviously, there are aggravating factors by statute that have to exist before you can even consider pursuing the death penalty. If you have a case, you review the case, you see that those factors exist, you have to determine from evidence and so forth what the best way to proceed is. If those factors exist, if you have the cases where a law enforcement officer is executed, a witness in a case is executed, things of that nature, those are ones that you would absolutely move forward on. In terms of the death penalty as it presently sits in our state, it disturbs me that it has been on a moratorium for as long as it has. I think that is incumbent on the folks that are stakeholders in the system, by law enforcement, DA's office, the Conference of DAs, to continue to have those discussions through the state level to find out what can be done to get that back in order so that it has a better impact on cases. So that if somebody receives the death penalty, it is actually a legitimate punishment that could be seen as opposed to it turning into a de facto life in prison. And if you have a homicide case where someone is serving life in prison and you have a case that is death penalty qualified, as was the case in our district, I don't think then you take a first-degree plea for a life in prison. You pursue the death penalty in that case.
Okay, thank you. And you will, Mr. Kiernan, you will have the first crack at this question. As a district attorney, how would you handle a use of force incident involving a local law enforcement officer? Specifically, if it makes a difference, talk about if it was a fatal use of force incident.
I'm sorry, did you say a fatal use of force?
A fatal,
Understood.
I'm sorry.
No, that's okay. I just wanted to make sure I understood the question. There are a couple of pieces that factor in there. The main thing is to find out what information that you can as quickly as possible to at least know what you are looking at. If there is a scenario where there is any type of a conflict, then you need to let that go to through the Conference of DAs to find another DA that can handle that if necessary as soon as possible so that you are not impacting that investigation and so that it has that complete openness and transparency for the public that they know what is happening in that case. Initially, one of the things that I do presently is I am on a list of attorneys that officers involved in use of force incidents have the ability to call for counsel before they make statements and so forth. I've received 2 of those calls within the last 15 months. Each of those, I was able to understand what was happening in the case, talk with the officers, advise them, and be able to assure them that I believed they were in the right. In terms of the DA's office side of that, I know Mr. Lee was involved in those same cases. You have to look and see and investigate, and not do the investigation, review the investigation, and determine whether there was a crime committed by law enforcement or not. And if not, if it's a justified use of force, that's what it is. And if you determine along the course that there's some type of conflict of interest, then it's your duty to move that case to someone else as soon as possible for the transparency and trust of the public.
Mr. Lee?
As district attorney, I have handled 10 officer-involved shootings. Mr. Kiernan has never handled any. I have made 10 decisions in those cases. I don't delegate those. I do not give those to other assistant DAs in my district. I make those decisions because I've got to decide whether or not that officer was justified, sometimes in taking a life. I'll get those calls from sheriffs, from police chiefs, and the first thing I ask is, first of all, was anyone killed? Second question, is the officer okay? Because I very much care about our law enforcement officers. At that point, then, I will request that the State Bureau of Investigation, or I'll join with the sheriffs or the police chiefs to have the State Bureau of Investigation investigate those. Immediately, I'm in contact with the SBI about those cases. I will work with them. I will meet with them. And then I will review the entire file, and sometimes these are hundreds and hundreds of pages. I'll read everything, watch the videos. I may have another assistant DA look at it, but I'm going to make the final determination, the final decision. I will then prepare my own release in those cases. I do not delegate that. I prepare my own releases. I will release those publicly. I put a lot of facts in those. I will release those to the media, to the family, to law enforcement. In each of the 10 officer-involved shootings I've been involved in, I have found all 10 were justified because the officers were in fact in fear of death or serious bodily injury.
Okay. I think we have time for one more question in the Q&A round, and then we'll go to the summations. I said summation, closing statement. Yeah, summation, district attorney thing. Okay. Please describe your policies or your approach regarding plea bargaining in drug offense cases. And Mr. Lee, I'll get you to start with this one.
Yes, sir. I can tell you what, in terms when it comes to trafficking and drugs, I'm not in favor of reducing those down to attempted, simply because that way the defense attorneys can get a probationary sentence. That is wrong. That is not appropriate. I know there's certain defense attorneys that would like to do that, but that is not the right thing to do. These people should be prosecuted. Second thing is sale and delivery of cocaine or other drugs. If you profit from the sale of drugs, your case should not be reduced down. Now, we must look at strength of case, but they should not be reduced down. They should not be given deferred prosecution or other some type of sentence that some of them may wish to do. I'm not in favor of that. You've got to be tough on selling of those people who sell drugs. They are profiting off the harm caused to others. That is wrong. For lower level amounts, we're talking like possession of cocaine, possession of marijuana. If it's possession and that person is an addict, this office will, in fact, work with defense attorneys trying to find them treatment. But it does not mean they will not be punished. They still must be punished, but we're also looking at more of a treatment aspect of that. That's for possession. That's for those who are addicts. Look, my office has been tough on crime. My office has been tough on drugs, and we're going to continue it. Because as mentioned earlier, it seems like almost all of our cases somehow derive either from alcohol abuse or drug abuse. So we've got to be tough for those who sell drugs and traffic in drugs.
Mr. Kiernan, the question is, how would you describe your approach regarding plea bargaining in drug offense cases?
I would start that approach with communications with law enforcement, specifically with the Drug Task Force across the district. One of the interactions that I've had, or one of the discussions that has been ongoing with officers in the narcotics enforcement, is they have a list of people they know are involved in this trade. They have a strategy that they work through. If they don't have the teamwork component from the DA's office to work along with that strategy and develop an even better strategy together, we're never going to make the dent we should be in the drug trafficking trade. When we're talking about lower level felonies, possession of cocaine, possession of heroin, the simple possessions, people that are addicts that generally don't have as much record, what a lot of folks don't realize is if they are a record level 1 or 2, they're mandated, they have to get probation to begin with. So it's easy to say that we're going to work with those folks because probation is there to get them those resources. When we're talking about trafficking cases and how to determine plea offers and so forth, and whether it's appropriate, I personally have handled 2 pleas in the last 2 years where the trafficking charges were reduced to attempted trafficking. So it definitely happens. I've had at least 2 of them myself. In terms of whether to make those decisions, again, it's evidence-based, career record-based with that defendant, and talking with law enforcement so that you are doing things in a proactive way to get as many of that off the street as possible.
Okay, thank you. And now we will get right into the closing statements, closing remarks, and Mr. Lee, you will get the first crack at this.
Thank you. It's been my privilege serving as the district attorney for the 5th Prosecutorial District. I've done so for 35 years. We have an office that has a lot of integrity, hard work, experience, because that's what the public needs. You know, both Kevin and I, because politics does come into it, both Kevin and I were both Democrats, and we switched to the Republican Party. We are both lawyers, but that's where the similarities end. I am a career prosecutor. Mr. Kiernan decided to become a defense attorney, and there's nothing wrong with that. But don't come back later and say, now suddenly I want to be the district attorney without enough experience. Look, I was raised in a military family. I have strong values. I'm in favor of the death penalty. I'm opposed defunding the police. I support law enforcement. I support people's rights to defend themselves with deadly force if appropriate. I've prosecuted death penalty cases. I've done 8. I have 35 people serving life without parole. I am a strong district attorney for the 5th Prosecutorial District, and I appreciate your support.
Okay, and Mr. Kiernan.
Thank you. I was a Democrat when I worked for 2 elected Democrat DAs serving at their pleasure. When I left the office, mostly for philosophical differences, not as much financial, I changed my party to align with my principles, which is the Republican Party. I have served the party well for the years since then. I did not switch my party the day after somebody said they were running for my seat for political expediency. I did it for political principle, for ideological principle. When we're looking at this particular office and what I would be bringing to this office, I also have the integrity. I am our bar counselor for the state. I was asked to serve in that role by all of the attorneys in our district because they recognize the legal ethics and integrity that I possess. I would bring that to the office. I would bring the communication, the proactive approach, that collaboration with law enforcement and with victims so that we could actually achieve and bring those caseloads back to normal and achieve justice throughout our district.
Thank you, and thank you, candidates, for the courtesies you've shown, and I'll turn it over to Lorette.
Thank you, Elliot. And I also want to say thank you to Kelsey Stiglitz, our timekeeper for today. She's done a wonderful job. And folks, let's give our candidates a round of applause. I also want to thank the City of Jacksonville for letting us use these wonderful facilities and their media services. And of course, thank you again to our sponsor, Duke Energy. Now, if you missed any part of the Forum Onslow, just check the listings for G10 for the broadcast time and dates. You can also find the forums on YouTube. But most of all, remember, your vote has power. Absentee ballot request forms are available online at the Onslow County Board of Elections website, as well as the dates, times, and locations for early one-stop voting. Election Day is May 17th, 6:30 a.m. to 7:30 p.m. at your local precinct. On behalf of the Jacksonville Onslow Chamber of Commerce, thank you for joining us for our Meet the Candidates Forum, and we do stand adjourned.